Representative Tanzi, do you, so there's a difference in misdemeanors, right? There's civil and criminal misdemeanors. Does yours only go after the criminal misdemeanors then? When, that would be when someone actually physically harms somebody else. Are you focused on all misdemeanors or just
domestic
criminal?
Violence misdemeanors that are specifically where there has been use of force or threatened use of a firearm. So these are not the arguments that people get into at the Thanksgiving dinner table. These are not yelling and screaming matches. This is when someone physically abuses someone.
So there has to be physical harm.
Yes.
Demonstrated physical harm. So it's a criminal misdemeanor that you're looking at, or?
I believe it is. I believe all domestic violence misdemeanors are criminal.
I don't think it says that in your bill, though.
Would you like me to ask counsel for their interpretation?
If I may just finish this, because it does a little bit more than what I said, so just to complete that thought. And domestic violence misdemeanors that include cyberstalking and harassment, which is one thing. It's not two separate things. So a conviction on cyberstalking and harassment. And then also those who violate the protective order. So those are the individuals who would permanently lose their right to own a gun. And the reason that we added those two was because after working for years on this bill, we heard loud and clear from survivors of domestic violence that these are additional, very large, very significant threats that they face. And then the data that has been produced, and there's mountains of it, and I'm sure we'll hear tons of it tonight, but these are crimes where there are direct, I don't want to use the word correlation, but those who commit these crimes are more likely to go on to commit a domestic homicide. And there is data to back that up. So we went and included them this year in the legislation.
Okay. I thought in your testimony you said that they would only be prohibited from having a firearm while the restraining order was in place. And now you're saying it's permanent?
So it's two pieces.
It's permanent.
It's permanent upon conviction of the violent, cyber, or violation of protective order, domestic violence misdemeanor charges. So you permanently lose it if you hit someone, you threaten force, you threaten to use a firearm on them. If you are convicted, again, of all of these things, cyberstalking, cyber harassment in a domestic violence relationship, or if you have violated a court-ordered restraining order. You're convicted of those crimes, you lose permanently your right to have firearms. The temporary one is for the final protective order. So you can go to the police and you can ask for a temporary restraining order. Those are granted widely with a low bar. And I'm sure, again, we'll have plenty of people who testify. Those are TROs, temporary restraining orders. Those are given out in emergency situations. The piece that my bill addresses is the final protective order, which everyone is noticed of the hearing date. They are allowed to come and testify on their own behalf. They are allowed to bring lawyers forward on their behalf. These are the type of hearings where a judge presides and makes a determination as to whether or not that person should have a protective order. Included in these orders are things like you must vacate the house, even if it is your house, but if you're...
I'm very aware of these.
Yeah.
So it's fine, except a lot of times temporary restraining orders become protective
but
orders
only after a
final
after a hearing. Yes, absolutely.
Because judges will err on. Judges don't want to make a mistake, so whether they see it as an imminent danger in a divorce case, they will tend to grant. Do you have the data on how often temporary restraining orders are issued?
Not temporary restraining orders.
And final protective orders in divorce cases?
You should have in your possession a groundbreaking study that was done by every town. It really truly is. We're the only state in which this type of research has been done because of our size, our benefits. See, small is good. We had researchers come in, and for 3 years they went through every final protective order application and reviewed it. So in every county, in both district and family court, and they looked at those applications and they looked for signs where there's a box where, at that time, there was a box where you could check and say, I would like to have the gun removed. So they looked for that. And they also looked for a narrative, because there's a place for a narrative in there that where they looked for key words such as, he has a gun, he has threatened to kill me, he has threatened to kill my children. And they looked through all of those and they found that those protective orders were granted. So there's a lot of data on that. But the thing that was most shocking was that when the lethality factors, as I mentioned, were high, where somebody asked for a gun to be removed or they said that they were threatened to be killed with a firearm, only 12% of the time were those guns asked by the court to be turned in. So victims are coming to the court.
How often do the judges not grant protective orders, or do they overwhelmingly grant them?
I don't know that off the top of my head. I have to say that the people who did, I'm sure it is, but it's not one of the things that I know off the top of my head. The person who did the study is here, and she will be testifying tonight, Sarah Tofty, so you can ask her those types of questions.
I think, I'm not a lawyer. I don't hang around in family court, but in my experience, in my knowledge, spouses will often use temporary restraining orders as a bargaining chip in divorce cases. And that is my experience. And I know plenty of cases where it happens. That's right. So
and I will say that
I'd like to know when judges don't grant them.
I will also say that one of the key things that we looked through when we poured through I believe it was 1,400 applications over that time period, we looked for things like relationship. Were these people married? And because we heard that very same thing that you say, the anecdotal, somebody uses it to game a divorce, and that is overwhelmingly not the case in the majority of cases. These are not people who are married.
You have the data on that.
That's certainly something I personally went through all of the applications, and I counted the number of times that the relationship was so it was less than 50% in each of those district courts and family courts, where fewer than half of them were in a married situation. So I know that there is this anecdotal evidence that people come up with, and frankly, it's just that. These are not women who are coming in and gaming. We're talking about a legal court proceeding. There is a 1-year criminal penalty. You can serve up to 1 year in jail.
I'm aware of that. I am aware of that.
So this bill does not address whether or not women or men are lying and perjuring themselves in a court of law. This bill takes for granted, yes it does, that people are being truthful, but there are other laws within our state that completely deal with that. And if there's any evidence, the people
you don't know if there's data on how many times judges don't give.
Personally, I don't, but Sarah Tofty will be in here tonight, and who knows, it might be a few hours before she gets up here. She might have the opportunity to crunch that specific question. I can't say for certain whether or not she has that specific answer for you.
Okay, and Chairman, you were going to ask whether it only dealt with criminal misdemeanor?
Would you like to ask a question of counsel, Lita Morgan?
That would be lovely, Chairman.
Please proceed.
So, who am I asking?
The counsel's at...
over at this table.
This table.
All right, thank you. So,
there are no civil misdemeanors.
So, but there is civil and criminal.
I think she's talking about pettit. I think she's talking about pettit. Pettit misdemeanors versus...
I'm not a lawyer. So when there's criminal, so there's no criminal misdemeanor, you're telling me, but there is a criminal...
Lita Morgan, every misdemeanor is a criminal word. So if you're talking about a misdemeanor, you're talking about a crime. Mr. Manny, would you like to answer this question?
Criminal misdemeanor, it's only criminal.
Right.
And it is defined under Rhode Island law as anything where the penalty is up to 1 year at the ACI and up to a fine of $1,000. Okay? Anything over that is considered a felony, any potential penalty over that. A pettit misdemeanor or minor misdemeanor as listed, there's only a few of them. That's anything with a penalty less than the 1 year. For example, disorderly conduct, is a potential penalty of a 6-month. There is a failure to relinquish a telephone line, which is under the domestic violence crimes. That is a 90-day penalty or a $25 to $200 fine. If you're asking about various no-contact orders or restraining orders, in a criminal case, when one is charged with a misdemeanor, oftentimes, if it's domestic, all the time, the court imposes a no-contact order immediately. Okay? That's in the criminal context. If you violate that, that is another alleged offense. There are other types of restraining orders and no-contact orders. You can go to family court in the divorce setting. In the instance where someone is abused, then you could either file a complaint for divorce with a request for a no-contact or a restraining order. In the restraining order portion of it, if that is granted, a violation of that is criminal. If you violate just the no-contact order, then that is considered a civil contempt under family court.
All right,
so there's various provisions, but primarily they do the same thing of keeping a person away from someone else. However, in the context of a criminal violation of that, it is another crime alleged.
Okay, so Leader, hang on one second. So, Representative Tanzi, it's your intention that this bill exclude pettit misdemeanors?
That is correct.
Okay. Leader Morgan.
So then pettit is out, and what was the other? Criminal.
Pettit and regular misdemeanor, but if I may comment, the disorderly conduct is a 6-month penalty. That's a pettit misdemeanor, so to speak. That's listed as a domestic violence crime. The definition of that actually is a person commits disorderly conduct if he or she intentionally, knowing, or recklessly engages in fighting, threatening, or in violent or tumultuous behavior. So the language in this bill indicates that it excludes that, but it doesn't appear to exclude it, because there's language in here about the use of force or threatened or attempted use of force. Disorderly conduct is violent and tumultuous behavior.
Behavior, but not necessarily toward a person or on a person, upon a person.
Okay, so well, as we all know,
my intent,
what your intent is, we all know when we draft bills, and certainly Representative Tanzi is not an attorney, we draft bills, sometimes we have to change them with substitute A. So I believe the sponsor has testified her intent is to exclude such behavior, even if it's not written that way currently, correct?
I absolutely do not want to include the pettit misdemeanors such as disorderly conduct.
Okay.
And have always been clear on that. Okay. And the failure to relinquish and the other ones.
It's a difficult thing to draft. So, yes, Representative Morgan.
One more, I think, to you. So during the time that they've got a pettit misdemeanor, under this bill, would they lose the right to go hunting, to go trap shooting?
Well, if you construe the language as it's presently written, it would exclude a person potentially who was convicted of disorderly conduct from hunting and trap shooting. Because the language is violent or tumultuous behavior, which is similar to attempted force or disorderly conduct is an old, broad statute that encompasses violent, reckless behavior, tumultuous behavior. So potentially it could be included, but it depends on the reading of that statute.
If I throw a wine bottle at you at the Thanksgiving dinner, that's tumultuous and violent behavior, but I don't hit you, and it's not included in my bill.
But there would still be could still be a restraining order, and they would have to give up their gun for up to 6 months.
For the length of that restraining order. Your restraining order and conviction on a petty misdemeanor, I think you're conflating two things. So for the length of a final protective order, you can't possess a gun. So if it's you who has the restraining order out against you, you have the ability to go back before that court.
Let's just say somebody, not you.
if I had a protective order out against me and I felt that it was unjustly done, I have the right to go back before a judge and ask for it to be overturned.
I get that, but then that requires you to get attorneys and perhaps a lot of expense.
And I
I get what you're trying to do, and that is to protect people. I get it, and that's a valid thing to do. On the other hand, if it's, I get angry at Thanksgiving dinner, and then I don't get to, to go target shooting or hunting or trap shooting, which is something that I do with my friends on the weekends. There has to be some bar there that there actually has to be physical harm done to somebody, not just that they yell or they might,
I think you'll hear some very compelling testimony from individuals this evening that will help you to get to the point where you understand this. It is...
I've been around a long time, and I've been through more than one bad argument at a holiday dinner. So
I hope you don't ever get hit, and I hope you don't ever live with someone who constantly puts you under the threat.
But that would
violence.
Be where you have actual physical harm to a person, right? Not just the pettit. What is it called? Pettit misdemeanor?
I think we can leave pettit misdemeanors off the table and out of discussion altogether, because conviction for a misdemeanor crime that I'm talking about for the permanent removal and protective order are two different things. But
your bill doesn't remove that, is what I'm understanding.
But I believe Leader, she's testified that is her intention. So we've all as legislators had experience with a bill may read a little different than we intend. So that's part of the hearing process. So that's good. Let me add that I think if you threw a bottle at someone, you'd probably be charged with something that's greater than a pettit misdemeanor. So if your intention is that sort of behavior would not fall under this, I think you missed the point, because I think you're likely to be charged with something greater than...
Ground.
Yeah.